In this video, we're going to talk about malpractice and legal liability. And I also want to point out that there's two articles in Sakai that I've asked you to read about this topic. One by Packman and others, which is Legal and Ethical Risk, a book chapter. And the other one is an article by Skip Simpson, who is a plaintiff's attorney, who I know, about risk assessment, or about liability and the risk of liability. Over the years, I've been involved in some of these legal cases. I think about 20 over quite a long period of time, maybe 20 and 20 years, when I've been hired to be an expert witness, sometimes by the plaintiff, who is the person initiating the lawsuit, and sometimes for the defense, who is the social worker who has been accused of malpractice. And so I want to talk briefly about what goes into these situations and some of the details about it. So sometimes social work students and sometimes social workers say to me things like, am I liable for that? They're talking about something they did, and the question is, am I liable for that? And the answer is always yes. As a social worker, as a professional, not as a private person, but as a professional, you're liable for anything and everything that you do. Now, what does that exactly mean? Well, it's basically the idea that anybody can sue anybody for anything. Now, that doesn't mean that anybody who wants to sue you, for whatever reason, can always get an attorney who will take the case. Most of these cases, the attorney, the plaintiff's attorney, doesn't get paid unless they win the case. And so they're very careful about choosing cases to get involved in, because it means putting in hours and hours and hours of time and their own expense money in order to try to win. So they're going to be picking winning cases. That's why a lot of trivial situations never reach this point. But anybody can sue anybody for anything. But how does this actually play out? Well, here's an important it's maybe another mnemonic in a sense, that malpractice consists of dereliction of duty directly causing damages, the 4 Ds. And there's actually 5 aspects to it. The one that's sort of implicit here is that you have a professional duty to your client. So anytime you're in a professional relationship with a client, then you have a duty to do the right thing by that client. So that's implicit in here. The second step of the 4 Ds is the dereliction of duty. That is, you didn't do something you were supposed to do, or you did something you were not supposed to do, that you violated what we call the standard of care. I'll get back to that in a minute. So you have a duty. You were derelict in that duty, in that you didn't do what you were supposed to do, and that directly caused damages. Damages means, the client died of suicide, the client broke his arm, something bad happened to the client, and that there's a direct connection, the 4 Ds. So to jump here to the second item, bullet point on this slide, malpractice is you did something that you shouldn't have done, or you didn't do something you should have done. The duty that we all have to do is called the standard of care. And the standard of care is what a reasonable and prudent social worker would do in the same or similar circumstances. Now, the standard of care, unfortunately, is not written down anywhere. NASW has some very general standards, but they're so general that they're not very helpful, because in each case here we're talking about what would the reasonable and prudent social worker do in the same kind of situation. So it's very detailed. So the standard of care arises, first of all, just again, what would this hypothetical other social worker do? It's also in books and articles about social work practice. It's also what you learn here in the School of Social Work. It's also what experts say the standard of care should be. And as you might guess from a concept like this that is kind of mushy and poorly defined, that a lot of people can disagree about what the standard of care is in a given situation. And they do. And of course, When a lawsuit happens, then the major disagreement is between an expert on each side disagreeing about the standard of care. Did this social worker carry out their duties according to the standard of care or not? Good documentation is an important part of this. The major way that you'll be able to show that you did fulfill the standard of care, that is, you did do what you're supposed to do, is from good documentation. And in addition to these two articles I mentioned, we also have a chapter by Shea in the book, the Assessment of Suicide, in which he talks about documenting suicide risk. It's really good. It's really important. As I mentioned earlier, the direct connection, and that is the plaintiff, which is the person doing the suing. In the case of a suicide, it would be the family of the person who died. They have to show that there's a direct connection between the violation of the standard of care and the damages that happened, and in this case, a suicide. If your working with a client took place in 2019 and their suicide took place in 2020, it would be pretty difficult to show a direct connection, given that a lot of time had passed in between. Although still, some lawsuits have been filed even with months between the treatment and the outcome. And I'm going to show you some examples coming up. As I said, I've been involved in about maybe 20 cases over 20 years, some on the plaintiff side and some on the defense side. We'll talk about those in a minute. But I want to mention that in each of these cases, the plaintiff's attorneys often make numerous different accusations. I guess you could call them accusations that the social worker violated the standard of care. And in these examples, I'm just highlighting the main ones, the ones that stand out in my mind. So here's one case that I call parental visit. The client was a 35-year-old single woman with a diagnosis of borderline personality disorder. She was in therapy for 4 years and had a very tumultuous relationship, as many borderline clients do, with her parents, with her friends, and with her therapist. And although this might, seems hard to believe, but a psychiatric hospital agreed to hospitalize this patient in their hospital in order for the outpatient therapist to go on vacation. That is, the client could not tolerate her therapist not being available to her, and so for the therapist to go on vacation, she had to put her client into a hospital, and this particular hospital in the suburbs with a kind of a campus-style setup agreed to do that. While the patient was in the hospital, the inpatient therapist had a family session. Her parents came in. Remember, her parents and she have a tumultuous relationship. And after the family session was over, the inpatient or the hospital therapist agreed to allow the patient to go out with her parents to the parking lot to pick up something that they brought for her without any staff member going along. And so the patient and the family went out to the parking lot. The patient got the item from her parents' car, but then turned around and ran out into traffic on the highway right in front, was hit by a truck, and died. All right? So how does this play out? In this case, which I can't even remember if this was my case or one that I heard about and got in order to write up from another social worker. And if it was the case I was involved in, I actually can't remember which side I was on. Anyway, the defense argues that the hospital and the hospital social worker did meet the standard of care, and their argument was that the family session went well, that patients who were inpatients frequently went out into the parking lot with visitors for one reason or another, and that the patient was not particularly upset or suicidal after the family session was over. The plaintiff's attorney argued that the hospital therapist did not meet the standard of care, and in particular that hospital social worker should have known that the session between the patient and her parents could have been tumultuous or explosive or dangerous or whatever. He or she should have known that and then not allowed the patient to go out into the parking lot. Now, I don't know the outcome, and that's common when I and other people are hired as expert witness, because so many of these cases get settled out of court. Very few of them actually go to trial. And when they're settled out of court, some money changes hands, and the social worker who was sued often, and through his or her attorney, does not admit to doing anything wrong, but the insurance company, who is the insurance policy hired by the hospital or hired by the social worker, wants to settle the case. They don't want to go to court, and so they do settle, and the outcome really isn't talked about. At least from an expert witness perspective, I hardly ever hear about it. Sometimes the social worker who is sued is very frustrated by this because they want to go to court and prove their innocence, quote unquote. In other words, prove that they did meet the standard of care. And unfortunately, they rarely get the opportunity to do that. Now, here's another case. This one I was involved in as an expert for the defense, expert witness for the defense. This one I call Gun at Home. The client was a 30-year-old married man who had a 5-year-old son and married. He was working in construction, but this took place back in 2009. There wasn't much work after the housing bubble collapsed, and so he was financially stressed. And not only that, but his wife was about to give birth to their second child, who he looked forward to and was excited about, but you can't help but think that there was fears of more financial burden on the back of his mind. So he was stressed and anxious about finances. He was a recovering alcoholic, had been clean and sober for 5 years, attended AA, but he did own a gun that he bought maybe like a year before. He had a group of friends that they would go out and do target shooting together. And on the occasion at hand here, he woke up at night for at least 3, maybe 4 nights in a row. Woke up in the middle of the night thinking about suicide, and not thinking that he wanted to die of suicide, but feeling afraid that he might kill himself. And he was not able to articulate this very clearly. But the gist of it was that he did not want to kill himself, but he was afraid that he might. So he and his wife, after the 3rd, maybe 4th, consecutive bad night, they went to an ER. This was actually in the morning, 10 or 11 a.m., where they were seen by the ER doctor and the ER social worker. He explained, the situation again, and waking up at night and not being able to sleep, and that these fears of suicide occurred to him, not that he wanted to kill himself. They diagnosed him with anxiety and depression, along with his alcoholism, and the ER social worker arranged for him to be admitted to a nearby partial hospital program for his anxiety and depression, which would begin the very next day. The ER doctor gave the patient sleeping medication, and the plan, when he and his wife left the ER, by then it was noon or 1 p.m. that day, the plan was to go home and get the gun and sell it back to the gun shop where he bought it. Meanwhile, the gun all along had been in a locked box, and his wife, the patient's wife, was the only one that had a key for it. So they left the ER, like I said, at 12 or 1 o'clock with this plan in mind. But unfortunately, they went home, and not long after they went home, his wife was in the house. The patient ran out into the garage where the locked box with the gun was. He had some big bolt cutters, so he was able to cut the lock off. He got the gun out, and he shot himself in the head and killed himself with his 5-year-old son looking on. So this obviously is a tragedy. And the family sued, the wife sued, even though she had agreed with the plan to go home where the gun was in the lockbox, take it and sell it back to the store, have her husband go to the partial hospital program the next day. In any case, she sued, and her attorney argued that the ER doc and the ER social worker did not meet the standard of care, that the patient should never have been allowed to go home with a gun at home. As I said, even though his wife, who was behind the lawsuit, agreed with the plan at the time. The defense, and again, I can remember that I was hired as an expert witness to defend the hospital social worker, and the attorney that hired me, and my argument was that the social worker did meet the standard of care, that having the gun at home in a lockbox with the wife having the only key was a good plan, And I would argue that 99 times out of 100, or I don't know, maybe 299 times out of 300, something like that, it would work. That this was one of those rare cases that it didn't work, but that the plan was still good. Also, backing up my belief that the social worker did meet the standard of care was that the patient had never shown any intent desire or any desire to die, that he was not impulsive, that he showed good commitment to sobriety over the last 5 years, which sort of underscored the idea that he was not typically impulsive and that he was able to make a commitment. Anyway, that was what I believe and what I argued in the deposition. It never went to trial, and again, I don't know what the outcome was. There's another one called Spring and Fall Golf, and the client was a 45-year-old divorced man, remarried, with a high income, and he worked for his own family's business in a southern state. He had a long history of alcohol abuse. He liked to play golf. This just caught my attention at the time, that he said in a deposition that one of his favorite pastimes was playing golf in the spring and fall. And I remember reading that and thinking, oh yeah, what's wrong with the summertime? And then I realized that in the southern state where he lived, it's too hot to play golf in the summer. He liked to hang out at the country club, but he became depressed, made a serious suicide attempt by an overdose, hospitalized for a couple days, and was seen by a psychiatrist and a social worker in the hospital in preparation to being his outpatient psychiatrist and social worker after he got out. Now, in this case, I was hired by the plaintiff, so I was arguing against the social worker. Both the psychiatrist and the hospital, or the social worker who became his outpatient therapist, wrote in their own notes that close follow-up was needed, but and they both of them diagnosed major depression and alcoholism. But over the subsequent 5 months, he was only seen 4 times by the social worker and only 5 times by the psychiatrist. He failed to keep a number of appointments. They referred him to AA, but it was never clear if he went. But there was no attempt by either clinician, and of course in my case, I was hired by the plaintiff to argue that the social worker did not meet the standard of care, which I did argue based on the fact that the social worker made no attempt to reach out to the patient. So unfortunately, about 5 months after the overdose, this guy went over to his ex-wife's house, stood out in the driveway, and killed himself with a gun. So the legal issue involved, again, as I mentioned before, there were many points where the plaintiff argued that the social worker did not meet the standard of care. The one that most important to me was that given the previous suicide attempt, and given that the social worker had even written in his notes that close follow-up was needed, that only seeing him 4 times over 5 months was not enough. And even though the patient had canceled some appointments, the social worker was obligated to reach out and make at least a number of efforts to try to pull him back into treatment, given the earlier suicide attempt. The defense argued that the social worker did meet the standard of care, that the social worker set up the appointments and it was the client who canceled some of them or failed to keep them. So you can see that the turning point here, or the linchpin about the argument, was to what extent did the social worker need to reach out and aggressively try to bring this client into treatment. Again, I don't know the outcome. And finally, the final one that I call overnight in the ER, and this was a case where I was also hired by the plaintiff's attorney. In this case, a 25-year-old single man with a history of bipolar disorder was brought to the ER after some bizarre behavior in the parking lot of a restaurant where he was just kind of, acting crazy, quote unquote. Somebody called the police and he attacked the police when they arrived. The police called the paramedics and he attacked the paramedics when they arrived. But eventually the paramedics gave him a shot of Versed, which is a benzo, a sedative, and he calmed down. He was seen in the ER at about 2 in the morning, and the ER doctor noted that he had delusions, that he had suicide ideation, and that he said he had a suicide plan. The doctor gave him Klonopin in the ER, which calmed him down further, and eventually, actually, the patient fell asleep for a couple hours. They drew blood to see if he had any, psychoactive drugs in his system, maybe hallucinogens or cocaine or crystal meth that could have caused this behavior. And several hours went by before the drug screen came back. The ER doctor was busy with other patients. But after several hours, the drug screen came back negative. The only thing he had in his blood was the Versed and the Klonopin. But given the bizarre behavior, the delusions that the ER doc had noticed, that the ER doc arranged for the patient to be admitted to the psych unit at the hospital. But there was a delay, and while the patient was waiting in the ER, at 7 o'clock in the morning, a new ER doctor came on duty, and actually there was no social worker overnight, and the new ER social worker came on duty at the same time in the morning, and they re-interviewed the patient, who by that time was calm and had awakened and said at that time he was no longer suicidal, that there were no obvious delusions that they noticed. So they canceled the admission and they sent him home. Unfortunately, about 9 hours later at home, he took a massive overdose and killed himself. He was discovered because prior to the overdose, his neighbor in his apartment building could hear him pacing back and forth and yelling at himself, basically arguing with himself, at times telling himself he should just die and he should kill himself, and then at other times arguing that he shouldn't do that, arguing about whether he should kill himself. So the neighbor called the police, but by the time they got there, the patient had taken the overdose and he died. So the defense argument was that the hospital and the ER social worker and actually the ER doctor in the daytime as well met the standard of care, because in the morning when they interviewed him, he said he wasn't suicidal and there were no obvious delusions or anything like that. The plaintiff's side, which I took because I thought this was a terrible risk assessment by the social worker, and I argued that the ER social worker did not meet the standard of care, that the patient was discharged simply based on the interview, which, by the way, took 10 minutes the next morning, that the social worker interviewed him for 10 minutes, that he had no obvious delusions, and he said he was no longer suicidal. But the social worker made no attempt to understand and integrate how he looked that morning with the bizarre and delusional behavior of the night before. Besides that, they didn't talk to the ER doc who was on the midnight shift, who observed and documented the delusions, the suicide ideation, and the suicide plan. They didn't talk to him, and again, really in the bigger picture, made no attempt to understand what was going on, to put together what this could be. And it was fairly obvious when you take a step back and look at it. The client told them when he arrived for the first time that he had a history of bipolar disorder. So it seems pretty clear that he was having a manic episode, or probably a mixed episode, which, if you recall, when I talked about the psychiatric disorders that predispose a person to suicide, bipolar mixed is one of the important ones. That he had a history of bipolar disorder, that he was having a mixed episode the night before with agitation but high energy, delusions, and he was suicidal, but that the Versed that the paramedics gave him and the Klonopin that the ER doc gave him temporarily calmed him down. It didn't really treat his bipolar disorder, but it calmed him down for the next 6 or 8 hours until he went back home and it wore off, and then his mixed episode reasserted himself. The suicidal thinking that had been there earlier the night reasserted himself, and he killed himself. Really a tragedy. But I felt, and there's more details to this that I don't have time to go into, but that the social worker did a terrible job of a risk assessment in a variety of ways. But the ones I just mentioned here are probably the primary ones. Okay, so these are some examples of legal cases. This one, again, I don't know how it came out. It didn't go to court. It was probably settled, but I don't know for how much. But these are some examples of some of the legal cases, and so it really, I think the bottom line here is that you need to do good clinical care, that you need to consult with your supervisor or with other people in the difficult cases that you're unsure about, and that you need to do good documentation. As Skip Simpson says in his article that I've asked you to read, nothing will stop a plaintiff's lawyer more dead in his tracks than to find good documentation on the part of the clinician that did the risk assessment. Okay, interesting cases. All right, so I'll see you next time.